Good afternoon, everyone. Let's go ahead and get started. My name is Alex Chang. I'm the Associate Dean for Information Services at Duke Law School, and it's my great pleasure to welcome you all to our second Faculty Author Book Talk series in this semester. We have two more coming in April and March. First, I would like to express my gratitude to Professor Gina Gill Fletcher, our Associate Dean for Intellectual Life, and her office for generously sponsoring today's lunch. I would also like to thank our colleagues in Instructional Technologies Consulting, as well as my wonderful partners in the library, Jennifer Behrens and Shauna Bangro, for their hard work to make this event possible. Today, we're here to celebrate the release of Professor Brandon Garrett's newest book, Defending Due Process: Why Fairness Matters in a Polarized World. It is published by Politan, a global independent English language publisher. Professor Garrett is a leading scholar of criminal justice outcomes, evidence, and constitutional rights. He's the inaugural L. Neil Williams Jr. Professor of Law and the founder and faculty director of the Wilson Center for Science and Justice. It is an initiative that brings together faculty and students to improve criminal justice outcomes. Today, we're also so honored and privileged to have Professor Jim Coleman join us as a commentator and a moderator. Professor Coleman is the John S. Bradway Distinguished Professor of the Practice of Law, Director of the Center for Criminal Justice and Professional Responsibility, and the co-director of the Wrongful Convictions Clinic at Duke Law School. Now, without further ado, please join me in welcoming Professor Brandon Garrett and Professor Jim Coleman.
Thank you for turning out for this timely discussion. Actually, to hear Brandon talk about his latest book, not necessarily the discussion, at least my participation in it. But in the Wrongful Convictions Clinic, we use Brandon's other book, Convicting the Innocent. We use it as a roadmap for identifying wrongful convictions so that we can look for factors in situations where there is not biological evidence, and so we can't use DNA to identify the innocent clients. So we look for factors that in effect amount to non-biological DNA that suggests that this may be a wrongful conviction.
And you know, the first book talk I ever gave about convicting the innocent was at your invitation and Sam Buell's invitation in this room. Yeah. And it may have been the first time I came to Duke and met people here and thought this would be a really, really nice place to
hang out,
to spend some time. Yeah. But that was the first time I'd ever spoken about a law book that I had written was here. So it's pretty exciting to get to talk about a new book with you.
Talk about a different book that I think honestly is more important than convicting the innocent, not so much because it offers solutions, but because it asks the important questions that we are to be addressing. And particularly, I think it's even more important today than it was 30 days ago in many respects. So why don't we get right in and tell us why you wrote this, because you couldn't have foreseen where we would be today necessarily.
Well, I've been working on this book for several years now, and I described some of the teamwork that led to the book, including the new collaborations that I formed. I guess it's been almost 8 years now here at Duke. But thanks to the Wilson Family Foundation, we have the Wilson Center for Science and Justice, and some of the interdisciplinary collaborations helped me to see with kind of the benefit of other people's eyes and other scientific disciplines what the fault lines were around procedural due process. So maybe convicting the innocent was like a roadmap to how convictions can go wrong, how innocent people can end up behind bars. This book is broader, and it's about fair process and why there's so many challenges. Some of these are old challenges, but I focus on three challenges to due process which feel very present and were becoming more and more pressing over the last few years. So first, like due process, it's not something that gets taught, procedural due process, in a lot of law school classes. That was actually one reason I also wanted to write the book. We learn in constitutional law why substantive due process has been, we have justices that are very skeptical of overprotection of unenumerated substantive due process rights, but procedural due process, that's the part that is enumerated, not once but twice in the Constitution, the 5th and 14th Amendments, and it requires basically notice, a hearing before someone impartial. And those three things are really, really important, and we can't take them for granted in many contexts. And threats to those basic fair process protections I talk about in the book, big picture, are the ways in which protecting procedural due process, not in the same splashy ways that substantive due process has met with a skeptical judicial audience, but a more gradual process of erosion in the courts concerning procedural due process, which we can talk about more. Second, threats to technology. And so people can be indiscriminate and not respect fairness rights. Technology does that when it's designed that way. Technology is very good at being indiscriminate to large numbers of people. And then finally, I talk about polarization and the desire, if you think your side is right and that other people are other and don't deserve it, if you want an outcome and not the process, you put the outcome first, then it's very easy to say those people should be silenced, they should be punished summarily, indiscriminately. Why should we bother with procedural niceties? So judges, technology, polarization, those are three overarching themes in the book. And for better or for worse, those are very pressing challenges around the world today, not just in the United States.
I think your book, you can sort of divide your view of due process into old due process and the new, or what you call digital due process. And the old due process seems kind of easy to deal with now, and you talk about things that you can do to deal with that. But the digital due process seems to present new and different challenges. And so I want you to talk about two things. One, you talk about research that both you've done and others that suggests that Americans, at least at 30,000 feet, are still believe in the values that underlie due process and the rule of law. But then the question is what happens on the ground and whether that's different, and then what's the consequences of that?
Okay, so I have some Q&A that I can do with all of you here. So old due process, William Blackstone, older guy, 1765, Sir William Blackstone wrote, "Better that 10 guilty people escape than one innocent person suffer." Sometimes people talk about that as the Blackstone ratio, like 10 to 1. We care that much more about protecting the innocent, that sort of 10 to 1 we should prioritize those safeguards rather than just public safety. We want to make sure guilty people are behind bars. And so one question is, sitting here today, what ratio would you choose? Do you feel good about letting 10 guilty people free to make sure one innocent person doesn't suffer? Would you pick like a 1 to 100, 1 to 2, 1 to 1, 1 to 0? Any thoughts? Like, how many of you are like 10 to 1? That's what I want. I'm with Blackstone. Any Blackstonians here? No Blackstonians. Okay, how about 1 to 1? You want to be like balance equal, like guilty person, innocent person. No? I got a hand. Okay, we'll ask it a different way. So this is the way we asked it, and this is how some of the big social science surveys have done it. What they say is, okay, which of the following errors do you believe causes more harm to society? So how many of you think it causes more harm to society to erroneously convict an innocent person? And how many of you think that it's failing to convict a guilty person? Which one? So starting with erroneously convicting the innocent. Which of you think that's the worst? That's worse. Okay, and how many of you think that failing to convict a guilty person, that's the worst harm? No, it's because we're lawyers. There are very few of us. There's some. Now, if I give you this option, you can change your vote now. If the two are actually equally bad, convicting an innocent person or failing to convict a guilty person, equally bad. No hands for equally bad? So the social science surveys, the main one in the US, the international version, they never ask the equally bad question. And my colleague, Greg Mitchell, psychologist and lawyer at UVA, we were puzzled that there are a lot of non-responses in these surveys, like people just don't want to answer the question. And so we thought, like, that's a problem when you ask forced choice questions. We've all had problems with forced choice questions. It's always a little harder maybe when there's a none of the above choice. None of the above choices are very important, by the way, in the eyewitness context. We can talk about wrongful convictions a little bit more later. So we've now surveyed over 12,000 people at this point and counting. These studies are still ongoing. Greg and I now have the benefit of really interesting collaborators, scientists that have come through Duke at the Wilson Center. And we've done a whole series of different studies. And we're probably now up to 15,000 plus people. The vast majority of Americans, not just half, but like more like 2/3 of Americans are exactly the way that none of you voted, which is they believe these errors are equally bad. These are equally serious problems. And in some ways, like, is that polarization? These are not people who believe with like the bulwark of our judicial system. You know, the Supreme Court has cited to Blackstone many times to say things like, where does beyond a reasonable doubt come from? Well, it comes from the due process clause, but why? Well, Sir William Blackstone said long ago at Oxford that we have to be especially attentive to the problem of convicting the innocent. And so Blackstone's ratio gets cited as this part of this long tradition going back to common law, that due process means, especially in criminal cases, you have to be really attentive to that type of error. That's not what most people believe. At the same time, there is some common ground there. It's not like people only care about public safety. We're just tough on crime. Americans, no. Like, Americans care equally about both fairness and public safety. And in our studies, we found this isn't just like some abstract view that people have when they're voting on the questions. It very much corresponds with how people behave when they're asked to be jurors, when they're asked to weigh evidence, when they're asked to deliver verdicts on vignettes or videos that mimic mock trial, trial type situations. It corresponds with how people make decisions in lots of different legal contexts. This isn't just like sort of opinion polling. It seems to reflect people's values. But the good news is that people aren't polarized. It's actually the vast bulk of Americans, all political parties, ages, different demographic characteristics. Just most people in general think that these errors are equally bad, both positive and troubling.
Yeah, I mean, so the question for me is that seems to suggest that Americans know what the theories of our system are and
Yes.
what underlies it, and that they think it's a good theory, or ideally it would be the way things should go.
Yeah, for example, I'm wondering if this is an argument you've sometimes used, like for judges or at the wrongful convictions clinic. I'm sure this is an important way of framing things. Like, one reason why those errors aren't actually equally bad is because, like, it isn't a zero-sum game where you're trading fairness versus outcomes.
Right.
And that's one of the themes of the book, is that these things are not zero-sum. Like, fairness is good for the government. Fairness can be good for society. Fairness can solve financial problems. It's actually can save us money. And one simple example in the criminal context is, if you convict an innocent person, by definition, if the crime did happen, it doesn't always happen, but if a crime did happen and someone else committed it, that guilty person has gone free. Right. And it's actually even worse. That guilty person is unlikely to ever be investigated. They may feel like some sense like, I can get away with anything now. It may make public safety worse when an innocent person gets wrongly convicted. Like, both bad things happened at the same time. I mean, is that something you try to do, to say, look, this is actually a public safety problem too?
That's how we try to present it, and when we when we do talks before public audiences, is to say that you shouldn't look at this as just the rights of a defendant, because I mean, I don't think that moves very many people, except maybe law school. But just among the public generally, I think you've got to sort of show them how this might affect you personally. Mm-hmm. That by according due process to this individual who was wrongfully convicted, what you may do in the future is prevent some other criminal from getting off and then being able to repeat it.
Yeah, yeah.
You talk about due process and equal process. What do you mean by that? And why is equal process important?
Well, so we've just been talking about what's the trade-off between fairness and other outcomes. Like, some people are just outcome-oriented, like we want public safety, we want criminals off the street, but then there's due process, there's fairness to the people whom the government wants to deprive of their life, liberty, or property. So that's one kind of trade-off. But there's another dimension, are we only treating some people fairly? Are there racial disparities or other inequalities in who gets the benefit of fair procedure? And that also links up with the problem of access to justice, which many of us here at Duke are working on. Many of the predictable arenas where people don't really get the fair hearing, they don't really get the notice that they deserve, are in situations where it's poor people, minorities, vulnerable people who can't take advantage of the kind of procedural opportunities that those of us who can afford lawyers and the like can handle. And so the Equal Protection Clause, the Due Process Clause, they're not separated by very many words. They're separated by punctuation. And yet judges haven't seen them as connected as they should. And your dean, Carrie Abrams, and I wrote an article together about the cumulative impact of different constitutional rights where a common harm is addressed by more than one right. This theory has been embraced in the access to justice context by the Supreme Court in cases going back to the 70s. We should view rights that belong together as addressing common problems. And yet judges haven't always seen it that way. One just quick example, in North Carolina, we've done a lot of work here at Duke looking at the patterns among people who have suspended driver's licenses. And their licenses are suspended indefinitely if they can't pay tickets or if they fail to appear in traffic court, often because they know they can't pay. And we have Rita Grunberg in the audience here who's been doing an enormous amount of work building out this data in a way that the public can interact with and understand. And racial disparities, class disparities are sort of manifest. It's, hundreds and hundreds of thousands of North Carolinians don't have active driver's licenses. And, for people who have resources like, for someone who can pay a $70 ticket, these due process problems don't come up. You don't see it. If you can't pay a $70 ticket, then it becomes a potentially lifelong handicap. And we've had events here with people who've suffered from these driver's license suspensions who haven't had a driver's license in 12 years, and they've been driving terrified that whole time, every day. We had a speaker here at Duke in the room next door who actually asked for a ride back downtown to work from one of our local lawyers because she's afraid to drive and has been for over a decade. But when that case was, when a due process challenge to those practices was litigated in North Carolina courts, the judge didn't view the race and class disparities as relevant at all. The question was just, is there a theoretical process on paper where if you can't afford a traffic fine, you can pay it? No matter that process on paper there was evidence, strong evidence that it was not being followed, that people weren't being informed that they have a right to have a fine reduced, reflecting their ability to pay. These people, you don't have counsel appointed in traffic court. None of those questions concerning how does this work on the ground? Is it actually fair on the ground? Is this procedure on paper actually followed? And what are the disparities that result from following the procedure on paper? None of that matters. A very formalistic analysis, and it's very common to see this. You don't see sort of an actual practical look at, so due process procedure, like how do these procedures actually function and what are the patterns? What actually happens when they are put into motion? And that's, it kind of encapsulates the problem that we see when courts look at procedural due process in this very stunted kind of formalistic way.
You made the point at the beginning about the difference, the distinction between procedural due process and substantive due process, and substantive due process is a thing of the past, basically. But you talk about procedural due process in ways that incorporate elements of substantive due process,
right?
In the sense that you think it should consider the fairness of the outcome.
Yeah. So there's certainly right there are much litigated questions about the degree to which unenumerated fundamental rights are protected by the Due Process Clause. But the words of the Due Process Clause say that people are entitled to not be deprived of due process law depending on if the government is trying to deprive them of life, liberty, or property. And it's procedural due process 101 that you need more protections if one's liberty is at stake, particularly a strong liberty interest. And you need fewer fair procedure type protections if it's just a temporary deprivation of your liberty versus a longer deprivation of your liberty. And if it's like a civil commitment or detention, there is less process that's required there than if it's a criminal trial, and the deprivation of one's liberty will be long-term. Similarly, if it's a property interest, like depending on the stakes, the government may not be required to assure, personal service of the notice. But if they're threatening to take away your house, and it's not just like a parking ticket, then there had better be a much more substantial process. And so we've always understood this, that due process is flexible but has to adapt to the stakes. Sometimes those stakes involve other rights and not just like the scope of the financial or liberty stakes. And that's a place where courts have foundered. And so if you're going to deprive someone of their parental rights, that's not like a financial interest. It's an enormously powerful interest and an important one, and courts haven't always taken that seriously in the calculus. Liberty it's very hard to quantify liberty, and yet courts haven't always taken that into careful account when they're deciding what process should people have afforded. And so I talk about that a lot in the book. That's not substantive due process. It's just how bad is the procedural due process violation? And often we don't have courts looking at that very carefully. One odd thing about that too is in some administrative context, the Supreme Court has said for decades now, we should really be focusing on like the scope of the harms and error rates. Like we should be doing a kind of a cost-benefit analysis under Matthews v. Eldridge, which many of you mostly see maybe in administrative law, maybe in civil procedure as well. And so you would think that, great, courts are actually going to take costs and benefits seriously. They will be looking at how serious the harm is to people when they are asking these fairness questions, and yet they rarely try to actually attach any numbers to these costs, or they'll just sort of talk about vague interests, and they won't actually engage with how serious the harm is to people.
Right, so let's talk about the old due process and some of the problems that you identify there and that you talk about. And these tend to deal with sort of lower level deprivations where people are losing benefits or they're being denied bail and have to stay in jail. How are courts responding to those challenges? And are they, I mean, you just mentioned that they're not doing the cost-benefit analysis that the Supreme Court suggests ought to happen. So what's the reason for optimism then?
I mean, there are good examples of courts really digging into the hard questions when old due process fails us. And, old due process and new due process can be pretty similar. And so, there are fears, which we can talk about more, like will AI or other new technology change the game and make it possible for the government to do indiscriminate things to lots of people? Well, old due process was pretty good at being indiscriminate too. And one quick example comes out of the work that I've been doing for 5 years now in Houston. And in Houston, before a consent decree was entered in 2019, which I and my colleagues ended up getting appointed to monitor, the magistrates were required to follow a very simple checklist. It was just on a piece of paper. There was no fancy technology involved, but it was just a checklist. And it said that if you were driving with a suspended license, $2,500. That was it. So bail hearings could be really short. There was no reason for a person to talk. If you had a lawyer, like what was the lawyer supposed to do? If you were going to defend yourself, what would you say? It didn't matter. The magistrate was required to say, oh, suspended license, you were driving, $2,500. And if you can pay it or get a bail bond, then you're free. And if you can't pay it, you're in jail. And so it was just a check sheet. It wasn't a fancy technology, but that's what all the magistrates were ordered by the judges to follow, and that's what they did. And that was challenged in a procedural due process suit. The judge, Lee Rosenthal, ruled that first in a preliminary injunction, and then went up to the Fifth Circuit, and there was litigation for many years. But the factual record and the rulings in that case reflected that this was procedurally unfair. There was no meaningful opportunity for someone to be heard or to describe whether they posed a public safety or flight risk. It was just a mechanical analysis. It was just a check sheet. And the judge to describe that there were serious racial disparities and class disparities. Class disparities by definition, people who couldn't pay ended up in jail. But race disparities in terms of the disproportionate jailing of black residents of Harris County. And so those patterns mattered to the judge. It wasn't formalistic. The judge was looking at what was actually happening on the ground under this bail schedule. Now, there are bail schedules like that in many parts of the country, and not all of them have been struck down. Most of them have not. It's also very hard to challenge these things. Like this, the plaintiff, or one of the plaintiffs in the case, O'Donnell, couldn't pay the $2,500 and would have languished in the jail and probably would have pleaded guilty after another couple of days, because what do? That's the only way you get out. And so how do if someone has pleaded guilty, they don't have a ripe case anymore. Fortunately, the lawyers were looking for plaintiffs, had just brought this class action, and O'Donnell could be signed on as a lead plaintiff, and therefore didn't plead guilty. And then this case went forward. But that's an example of like a really context-specific, detailed analysis. And by the way, what we found over the years, the predictions of some of the people who were really worried in Harris County about this consent decree was, oh, people like O'Donnell, they're just gonna like drive without a suspended license, knowing that they're gonna get a get out of jail free card. Like crime is gonna go through the roof. It is not a small county, it's the third biggest in the country. 50,000 people a year arrested for misdemeanors. Like how are crime rates gonna skyrocket once everyone realizes that on a misdemeanor, you're unlikely to end up in the jail? And what we found we're about to release next Saturday, we release our 7th report reflecting 5 years of work. We found every step of the way that once again, it isn't this trade-off between fairness and public safety. We have found that public safety has benefited from these reforms, that fewer misdemeanors, many fewer, are spending any time at all in the jail. And misdemeanor both arrests and rearrests, most importantly, have stayed flat. It's actually been good for public safety and has protected the liberty of hundreds of thousands of people at this point. And the idea that like procedural due process could be a win-win, that was not what people thought, especially among the opponents to these reforms. I mean, now bail reform is almost a bad word, and yet these reforms really improved public safety in a major county at an enormous scale.
You also conclude, though, that even when there are flaws in the system, they can generally be fixed at fairly low cost.
Yes, yeah.
And the question is, so why don't we, even on this level of due process, why aren't we willing to pay the cost? I mean, in one case, you identified a situation where people weren't getting noticed because they were sending them to addresses where they no longer lived, and you needed somebody to figure that out.
Yeah, like if you, one of the things I talk about in the book is some of the cost work we've done in Houston, where, and people say this in lots of jurisdictions, we all hear this as an access to justice matter. Like, oh, the idea that you're gonna, have lawyers appointed for people in traffic court, or have lawyers appointed for people at bail hearings. I mean, bail hearings, that just decides whether people end up in jail or not. Like, why would you have a lawyer there? People assume like you have a right to counsel in criminal cases, but not necessarily at these crucial early stages of criminal cases. So even in criminal cases, people don't necessarily, have a lawyer. And it turns out the cost of having a public defender present at these bail hearings is just minimal. It's not a lot of money. Like public defenders' offices are staffed, they're larger, you're not paying people by the hour, these are staff employees. And the cost savings, conversely, to Harris County, because the cost of booking someone every hour that someone spends in a jail is enormously expensive. And so, due process can pay for itself. Similarly, like if you're going to suspend someone's driver's license for years and years, and they don't have a lawyer, they have no way to find out what happened to them, they're not getting the notice because it doesn't get mailed to the right address. Big lawsuits around the country over terminations from Medicaid, where notices were sent to the wrong address, or they were posted on some online portal that people don't know about. You don't want people to have serious errors affect their lives. People to end up with medical emergencies and they don't have coverage, and they end up in an ER. Like, society pays for that. It's really, really expensive when those errors happen. Whereas the cost of correcting addresses, that's not that much. And there was actually a really nice passage in an opinion on civil forfeiture this summer, where basically the court said, this isn't the right case, we're not going to address these questions about due process and civil forfeiture. But there, Justice Kavanaugh did note that, when you have concerns about the fairness of a process like forfeiture, fairness benefits people who, there was a case about people who lost their car for like long periods of time in Alabama before they really got the hearing, and often their car had been taken for not fair reasons. They got their car back, but they were left without a car for like 2 years. And Justice Kavanaugh says, you know what, this isn't like just the person's fairness right versus society's interest in erroneously taking someone's car. Like it's good for the government too, for people to be able to get to work and drive and have their right to travel. And so there was a good acknowledgement there that due process, it's not like our rights, but the government really should be taking as much of our stuff as possible. As much of our liberty, as much of our property. No, the court said, like, really there is a strong interest in fairness that the government has and that people have. It's a shared interest. So I hope that's promising in terms of what happens when the court revisits that procedure. But I think it's also why, like, it's not a scale where the government the government shouldn't and doesn't have an interest in arbitrarily taking people's licenses away or fining people for no reason. Like, the government shouldn't have an interest in doing things indiscriminately. But the government sometimes does things indiscriminately. And unfortunately, sometimes the government proudly does things indiscriminately. And that raises serious questions about the rule of law and due process, because there is no government interest in doing things indiscriminately. That just sort of fails due process 101.
Right. So we've been talking about checkers, and I think, the real problems that you identify are sort of in chess. The use of technology, it sometimes, not only is it the government and the individual, but also the vendor, and proprietary interests of the person who develops the systems. Can you talk about that a little bit? Just kind of the complexity of it and what kinds of trade-offs are being made or not being made.
In some ways, like with the bail checklist in Harris County, no one looked at that and said, "Oh, wow, that must be really accurate." Like that's like really high tech and impressive. So of course the hearing officer should go down that checklist, and when they get to suspended driver's license, $2,500. That's accurate. Yeah. That's like cutting edge. But if the same thing is done with a black box risk assessment instrument where no one knows how it works, but it says high risk, detain that person. People might be thinking, well, we should use that because that's like really high tech. And technology has brought wonderful things to our lives. These black box systems that we don't really understand, sometimes they really do recommend good movies to us. Sometimes maybe not. The stakes are low when those things happen. The stakes are very high, and it matters how it works if it's being used in the justice system. And we've already started to see this in criminal cases where you'd think due process would be at its height, and we shouldn't be relying on something that we don't understand. And that said, due process has meant that we haven't seen AI technology as trial evidence yet in this country. Right. It's sort of been creeping into the places where due process is the weakest. And so we've seen AI used at probable cause hearings. How did we find this person? It was a facial recognition hit. How did it work? Well, we don't know. It's a black box. It just works. We've seen risk assessments used at sentencing and at bail hearings, but not at trial, because if you have to explain to the jury where there's due process beyond a reasonable doubt, how do you tell the jury that this person is high risk? Because the machine says so? There's an expression that my colleague, all of our colleague here at Duke, Cynthia Rudin in the computer science department, and I have used to describe how we think AI should work when rights are implicated, and that's glass box AI. And the idea is you should be able to see what factors it relied on and with what weights. You should know what the research tells you about whatever prediction it's making. And so if it says someone is high risk because they are 18 to 25 and they have 5 different prior robberies, and this person was arrested for a robbery, then at least you can look at that and say, oh, wait a minute, this person's actually, like, there are lots of errors in criminal justice data. This person's actually 26. Those prior arrests, they were all dismissed. And so this person has a record of dismissed charges. Like, I can situate that and decide what to do with it, and maybe not so much if the prediction is relying on that data. But if it just says high risk, then there's no way for us to mentally process it in the criminal system. We have started to see some good rulings from courts. I guess the upside of technology that seems unfamiliar and creepy is that some judges have looked at this and said, well, wait a minute, like, what is this? Whereas with the bail schedules, judges are used to it. Like, we've always relied on these things. It's old due process, it's bad old due process, but we're fine with it. And so there have been some really interesting positive decisions with, AI-enhanced video or facial recognition, where there have been concerns with reliability. People can sometimes see the reliability issues more clearly if it's something familiar, whereas if it's an eyewitness that was shown a suggestive lineup, people are like, oh, we've always done that. Whereas if it's facial recognition, we have no idea how it works. The unfamiliarity does create some opportunities to protect due process rights.
Talk a little bit about the a New Jersey case where the court required them to disclose at least some significant amount of information about the system that they were using it.
I have an update since the book came out, too, about that case.
In fact, you have 2 or 3 cases that are kind of continuing.
Yeah, some of the cases I talk about in the book were kind of in the midst when the book came out. There's a case in New Jersey that has also been a really good training example for judges, and highlights a number of issues when you use AI in the criminal system. So facial recognition technology has been rolled out kind of nationwide through government systems, through private vendors, without any particular regulation in almost every state, although there are a few that have some regulations. And normally, Jim knows better than anyone how things can go wrong if you show an eyewitness some photos, particularly in a suggestive way. If you show jurors like one photo and say, so, we'd like to talk to you, we brought you to the station because we've been continuing to investigate the convenience store robbery. How about this guy? That would be a very suggestive and unnecessary show up. Like, I had time as the officer to prepare a proper lineup. But what if I say, so we've continued to investigate the convenience store robbery, and what we did was, you didn't know the person who robbed the store. We didn't know the person who robbed the store, but there was surveillance video, and we used, an AI technology called facial recognition to run searches across millions of photos. And using this incredible technology, do you recognize this photo? Something like that is what happened in this Arteaga case, where in a New Jersey town, there's a convenience store robbery. The employee could describe the person kind of vaguely, and they had an image from the surveillance video. And it's pretty common for all kinds of places to have video cameras where you can get a still image. The still images aren't often great. And actually, I mentioned the glass box AI work I've been doing with Cynthia Rudin. Cynthia was one of the people on the National Academy of Sciences committee that met last year and issued a landmark report saying there needs to be fundamental testing done of these systems. That we have seen an enormous number of errors anecdotally come out, especially in cases involving black persons' faces, especially in cases where the image taken from the video or whatever was of poor quality. But those are anecdotes, and we don't know systematically how good these systems are because testing is in its infancy, and yet it's being used. In the Arteaga case, the position of the government was like, yeah, we don't know how the system works. We actually, we didn't get any hits in our New Jersey system, so we just ran it in New York, and the NYPD ran it. But we don't know what their vendor is. That's a different police agency. But it doesn't matter because we're not going to introduce facial recognition at trial. Who's going to testify at trial? The employee at the store. And the employee at the store, she's going to say, that's the face. That's the guy who robbed him. And so, this AI stuff, that was part of our investigation, but it's not relevant in court. You have due process rights in courts, great. So question the witness. And this is the combination of old and new due process, really. What the New Jersey appellate judges said was, there's the AI, and then there's the people. And that AI system gave a prompt, an image, which may have distorted the memory of the eyewitness. And the detective may have had, the detective picked out the photo out of the candidates that the detective thought was the right one. Those photos actually have the person's criminal record on the back. And so if Arteaga, oh, this is someone who lives in this town. Did the person have priors? I actually don't know. They have all kinds of extra information about the person. And so there are a lot of human biases that are adjacent to the AI. Anyway, what they said is if you're going to use this in court, we need to know how it affected the memory of the eyewitness. We need to know how the system works. You need to give discovery to the defense so that they can know how the database was designed, how it was queried, how this all works. And that would have been really exciting to actually have hearings on that and learn more about how these systems work. After the book came out, and by the time the appeal had been decided, Arteaga had been in pretrial detention all that time. And the appeal gets decided last year, very exciting opinion, I talk about it in the book. since the book came out, and Arteaga has talked about this to the press himself, he was like, I have children. As a father, I see my children hurting. Like, it's been more than 2 years now I've been in pretrial detention. Like, I'm glad my case made some good law, but I don't want to make any more good law while causing this terrible suffering to myself and my family. Like, I'm not going to roll the dice with a trial. And that's it for me. And so he accepted a plea rather than continue to litigate these, issues that were novel to lawyers interested in AI like me, but this is his life. And we see that a lot when novel issues are brought up in criminal cases.
And sometimes not just novel issues. I mean, sort of run-of-the-mill issues. People give up their rights because the process is unfair, and it's drawn out. And
People accept pleas when they have powerful new evidence of innocence, right?
Exactly. One of the interesting things, though, about the data that the court required the state to turn over was what could be called alternative suspects.
Yes,
right?
yes.
Which is sort of very interesting if you're doing wrongful convictions investigations.
What were the other faces?
Well, not only, exactly, what were the other faces, but also then you can see if any of those faces turn up in other evidence, right? The documents that they're withholding from you. You find that there was an alternative suspect whose name they had from a tip that they didn't pursue.
Well, it reflects this kind of one-sided view of technology. Like, why can't those database searches be used by defense lawyers?
Right.
Why is it so hard if there are potential alternative suspects to run a fingerprint or to run the video or image from the video or to get access to DNA data banks on the defense side? If this is evidence that's accurate and helps with public safety, why can't we use it to help with liberty too? And yet often these technologies have been procured by government and the defense has no access. There's just one-sided access to that technology. And we see that time and time again, in the welfare context, interest in preventing fraud, but not, in both kinds of errors. Mining the system to look for errors in granting benefits, but not mining the system to look for errors in denying benefits. We see this time and time again, and that's part of the problem. Like there's value in protecting fairness for all sides, and yet we see kind of selective use of technology, selective concern with fairness.
I have to admit that I had no idea when I started your book the difference between a black box and a glass box, but I'm beginning to appreciate that now. One of the things that's interesting is that you talk at the very beginning of the book, you talk about Ferguson and how they were fining people in order to pay for government. And then when you talk about the technology, you talk about red light cameras, which seems to be basically the same thing, except that, one, if it's a black box system, you don't know how they're adjusting. So these are cameras on red lights where, you have certain time to get from, when the light turns yellow, you have a certain time before you'll get basically caught for running a red light, and they can adjust the amount of time you're given. So if it's 7 seconds, then most people can make the decision to stop. Yeah. If it's 5 seconds, then you're going to run the red light.
Well, the concern is, right, if it's 5 seconds, like, people also may not have time to stop to prevent accidents,
right,
where you could actually be revenue generating for government using a system that actually endangers people's lives who are driving, right, which is also kind of terrifying. We've seen much more public pushback to these red light systems because, what happened in Ferguson is that, police were really targeting indigent people, black residents, people who couldn't afford traffic tickets. They were selectively targeting the population to try to revenue generate for government. Whereas, AI cameras are somewhat more indiscriminate. It's not indiscriminate where you put them. And so you can also put them in neighborhoods that are poorer neighborhoods. But to the extent that you put them in fair places, they've generated a lot more broad public opposition because lots of people drive, and at least people who can afford cars drive. And we've seen a lot more pushback when people see unfairness affecting them. Like, we all feel unfairness really deeply. Right. And that's sort of like the first lesson of procedural justice research. We all care about unfairness. And they're just wonderful examples of how, like, if you make fairness present to people, they will fight for it. We all care about it. I talk about how, for example, law enforcement groups were aggressively challenging efforts to provide more fairness at bail hearings. And even though like nerdy researchers like me were finding that doing that actually is good for public safety. But when the shoe is on their foot, when police unions have said, like, wait a minute, you can't discipline officers without giving them a hearing first. Like, due process matters in this country. We really need to have a fair hearing before you're going to impose discipline on an officer accused of some type of misconduct. That's just due process for government employees. It's due process 101, and it is. We need to have fair hearings on both sides, and that sometimes gets lost, but the hope is that people can see it. Like, if due process matters to you, then it should matter all around.
So you come down on a position that if we're going to use AI systems, it ought to be glass box.
Yeah.
But I mean, realistically, do you think that's the direction we're going to head in, or?
That hasn't been the direction that we've been heading in. I mean, more and more of these products are being rolled out without any particular, so A, they often haven't been tested so that we even know how good they are and how well they perform. And B, they are often a black box where the developer doesn't want to say how it works, and it just gives you like a prediction, a thumbs up or a thumbs down. I mean, what's been really insightful about the work being done by Cynthia and collaborators in the computer science department is that, you know, if you say this black box system that no one can understand works better, that there's a performance advantage, that, you know, to get the benefits of this technology, we just need to let the machine do its learning on its own. Because as people, we can't learn like machines do. Just run the machine and it'll come up with predictions that are so much better than what we could. And that can be true. Like, machines are much better at identifying patterns, but really that's not the right question. The question is, when you tell the machine to do those things, to look for the patterns, if you design it in advance that the machine is telling you what factors it relies on and what the model is actually doing, if you design it so that the predictive model is glass box and it tells you what the factors are in a way that you can understand, does that simpler system potentially, does it actually perform worse? Do you lose some of the benefits of AI when you simplify the system like that? And what they've done is they've done performance tests. Like, that's an empirical question. Is the glass box AI worse or is it better? And they found time and time again that it performs just as well. And it's better for these other reasons, because you can catch mistakes, you can actually use it. And, you know, we've seen this in research that we've done, meaning me and lots of different collaborators, where, you know, as lawyers, like, we didn't go into law, most of us, because we knew anything about numbers. And while I've been really fortunate to work with scientists, like, I'm definitely not one, lawyers aren't the most numerate people. And so what happens if you give lawyers like black box AI recommendations? The danger maybe is that they would just rely on it, like the hearing officers did in Houston. They just follow the bail schedule. But danger number two is, like, they don't know what it means, and so they ignore it, or they rely on it selectively. And that was what we found when we were surveying and also looking at data from judges in Virginia, where there was a risk assessment system. They're like, we don't understand it. It has some numbers. We're not going to use it. Seems like fuzzy math. We don't get it. Seems like Minority Report. We don't like risk assessment. We've never been trained on it. No one's ever talked to us about this. It involves numbers. It's confusing. We're just not using it. And they didn't. Or they selectively used it. Some of the judges did sort of understand it, and they used it. Most of them didn't. And that's also a danger. If you want to provide a tool that people are actually going to use, then they have to understand how it works to correct mistakes, but also just they're going to ignore it if it seems confusing and it's a black box.
Should we be concerned in terms of this AI technology about the government's access to a lot of our personal data that in turn is turned over to private interests that can use it to train their AI machines, and all of a sudden they can sort of pinpoint us as individuals, they have so much data?
So there are lots of privacy concerns with the uses of this data. And there are lots of concerns in specifically in areas that really matter to us as lawyers and that matter to due process. And some of this isn't like complicated or unusual metadata. I mean, it's been a pressing issue in the area of wrongful convictions that lots of law enforcement agencies like sell the mugshots and release that data. And so then you have all these faces. And so you can try to do an unbiased lineup, but if people control for faces online and decide for themselves, like maybe I can find the person that mugged me, that's a big problem. Or you could have people who become suspects because their private information is available online in these different spaces. But there are also real concerns that bad things can happen to people because of errors in government data. And what due process allows us to do is to potentially correct serious mistakes that affect our lives. And so if, I begin the book talking about a case involving people's public health care benefits or Medicaid benefits in Florida, and people are getting these notices that made no sense. It just said income over limit. Like, what income? I have no new income. But ideally, if there's due process, you can correct that and say, no, I don't have a job now, I'm still unemployed. Whereas if that, at least you could connect that, hopefully, if there's due process with the government agency to say, here's my unemployment information, please resume my Medicaid benefits, you fix that problem. But if the data is shared with someone else, then there's no due process with them, there's no chance to correct the errors, all kinds of things could happen to you. Should we?
Yeah, let me ask you one more question, and then I'll throw it open to everybody to ask questions. You make a distinction between the rule of law and due process. And what I'm wondering is, isn't right now the rule of law more important to defend that? Because, it seems that it's clear that Americans don't have the trust in our systems that the rule of law demands. And so what should be our focus? Should it be rule of law or should it be due process?
Due process covers so much of what we care about with rule of law. So, there isn't rule of law if you don't have an impartial judge or decision maker. If the government is doing something serious to you and you don't have an impartial decider, that's a serious problem. And what is rule of law if the government can take away your life, liberty, or property without any particular fair procedure? That's a lot of what we care about with rule of law. Rule of law also brings in some other important values, like having some consistency in decision making. Although that arbitrariness is a due process problem too. There's an awful lot of overlap between rule of law and due process. But I do talk about due process in a broader rule of law sense in this book, to the extent that due process isn't just about formal procedural fairness. If people lose faith that the procedures are fair, then that implicates rule of law. It implicates people's view that the government is legitimate, that they have anything to benefit from the system of law. That they're, if they think that it's just a system of men and not laws, then you can kind of have a due process death spiral. People won't feel like they can get any fair results from the courts. They'll resort to extrajudicial means. Those who have resources may be able to do that better than others. And you may have more and more polarization where people won't see the value of even investing in fairness because it's not going to benefit anyone anyway. The system is so broken. And then things become really, really, really serious. It's very hard to repair due process when things have spiraled in that way. And that's what I think we need to really fear in this country and in many places around the world. If everyone thinks that the government can do things indiscriminately to people and that there's no remedy, then that doesn't leave the law with much in the way of a foundation.
Okay, I'm going to throw it open. Questions? Yes.
I'm Jeff Swanson, an interloper from the medical school and a mental health services researcher. And I wanted to go back, Brandon, to your audience poll at the beginning about the Blackstone ratio. And I'm wondering if you can comment. I couldn't answer it really because the answer was it depends. And I wonder if you could comment on an analog from clinical medicine, which is the number needed to treat. If you have a medication or something with uncertain efficacy and not a very benign side effect profile, and you say, well, how many people do you have to treat for one person to benefit from that? And
yeah, we've asked questions in that way because it might be that like balancing one harm versus another is just hard for people to do, and so we've asked it in different ways, like how many, if you have like 100 people and half are guilty and half innocent, like what would you do? Or if you're going to spend tax dollars on preventing wrongful convictions versus making sure that guilty people do get punished? How do you divide up those tax dollars? And what we keep seeing every time we ask these questions is it's half and half. It's both valued equally. We've split it into like 8 different gradations. People come in the middle. Like no matter how we ask the questions, it seems like people gravitate to this view that both errors are equally serious, and there's some hopeful things about that. It does mean that people care a lot about fairness, but they also care a lot about outcomes.
Walter
Sam.
first, and, well, Walter and Sam.
Great. So I wanted to ask what people need to know or understand.
Yes.
Because it's easy to go, they ought to understand how it works. It's not easy to understand how it works.
Yes.
And if all they need to know is what the factors are, well, with Compass, they know what the factors are. You know the 137 questions. What you don't know is how the algorithm puts it together. So what exactly do they need to know about how the AI system works for it to be due process?
So there isn't a quick answer to that because it may also depend on, due process depends on the stakes. And so having some information about how it works may be enough in more low-level contexts. If it's a trial or if it's a criminal trial in particular, you may need to know a lot more. It's, not just the factors that it relies on. You may need to know the weights. You may need to know how it was tested and whether it's reliable. And accuracy matters for due process too. So there isn't a quick answer to that question, but it'll depend on how seriously people's life, liberty, and property are being affected.
Sam.
So, Brandon, this is great. I want to ask you about the polarization or sort of public attitudes piece of this. And one of the things that's great about your work is you're always studying discouraging things, but you're not a pessimist. The optimistic thing, right, is people care about fairness. And one of the things that we've observed, I think you would agree with me, particularly in the business crime context, where you often have well-litigated cases, good lawyering, is that there's a big divergence between people's public attitudes towards business crime. The healthcare of the CEO of a major healthcare company is murdered, and a lot of people don't seem to actually be all that upset about it, right? Well, when they're sitting on juries, they often, go to great lengths to give even the most scandalously indicted people, a fair shake.
Yes.
So the question is the decline of the jury trial part of a problem here? And is there a way to look at the extent to which people who've had individual interactions with the system, not as defendants, learn and are better advocates for due process?
I mean, more broadly, there's this question that we've been interested. We have a study or more than one study that we're thinking about at the Wilson Center. Does putting people in a deliberative mindset around weighing fairness versus outcomes, does it cause people to view things a little bit more differently than if it's just sort of more like the very limited interactions people may have, and social media may sort of encourage this, like something I don't like, cancel it. Some person that did something harmful, punish them. But when you put people in a place where they actually have to talk to each other and decide something, and maybe that they weigh these competing values in a more nuanced way, because all of a sudden your role is different and you're doing something more deliberative. That's the hope and that's really like why we have juries, right? Is that we want people to actually weigh things and not just reach snap judgments. That's part of what due process is for.
Matt.
Thank you for this fascinating conversation. So Brent, let me just ask you a little bit about the political economy of fairness. I mean, from a certain point of view, right, it's puzzling there's all this unfairness, right? There's all this unfairness, and yet, on the one hand, you said people don't like unfairness. People really care that processes be fair. And fairness is not just unfair. Unfairness is not just unfair; it's also costly, right? So that's a bad thing, right? And so why is there all this unfairness? So maybe just talk about that. So in the case of incarceration, is it sort of the jail and prison lobby? Is that what it is? So interest groups on the other side. Is it bureaucracy? I mean, what accounts for all this unfairness, given that people care about fairness and unfairness is costly?
Yeah, I mean, the last point is like it may be, unfairness may be costly to government, but there certainly may be others that are profiting from it. And same true of, the vendors of these AI systems. And they've often said that in court, like, we don't want to have to disclose how our system works. Like, we actually can do that. We do know how it works, and it works very well. We will tell you that. But we have a proprietary interest in making money off of selling this product. And so why should we have to tell you how it works in this criminal case? In the same way, we've seen in our work looking at costs, we know what fees people were paying in misdemeanor cases in Harris County. And although these are low-level misdemeanor cases without big cash bail amounts, the volume was huge. And so it was tens of millions of dollars that the local bail bonds industry was making over the old cash bail schedule system. That rudimentary system was hugely profitable. And they would, these aren't cases where they would ever be asked to like pay back the money if the person didn't show up in court. Like, no one paid attention. It was very low risk, very, very profitable work. And so it may be that the government was losing money off of that system and paying an enormous amount of money to detain people at great expense in the local jails. These low value cases, like, this is not what the jails should have been for. But there were certainly people who had a lot to gain from that system and would like to see that system come back. And so it is a very good point that it may be that the government doesn't profit from fairness, but industry might.
Okay, I'm going to call it. Thank you for coming out. Thank you, Brandon. Great book.
Thank you, Jim. I didn't have time to talk about it, but that first case I started the book with, it went to trial in the fall.
Okay,
And I got the trial transcripts.